How do most workers' compensation cases typically come to an end? Do they settle? Is there an award? When you finish your workers' compensation case, there are several potential outcomes, okay? The first possible option is that your case might just go idle and it might just close and it might just kind of die. And it's not because you had a bad case, but you got what you needed. You got the benefits that you're entitled to for your lost time. You might not have any permanent disability. You might not need any more medical treatment, and that's it. So if you recover fully from your injuries with no permanent disability, and you don't need any further medical treatment, and you were paid for your lost time, your case might just simply close. Now, here in New York, those instances where your case kind of just dies and idles itself out is happening less and less. The Workers' Compensation Board might actually still push your case towards a permanency determination, and that would ultimately be a determination that you have no permanent disability, just to get that finality. The board has kind of been doing that more and more lately. Another way your case might close is with what's known as a schedule loss of use award. If you suffer a permanent disability to an extremity, arms, legs, hands, feet, fingers, and toes, you might be entitled to a schedule loss of use award. This is determined by the percentage of loss of use that you suffered to that particular body part, and it's often paid as one lump sum. The amount is determined by the schedule loss of use chart, and that chart shows us what the value of each body part is. For instance, an arm, total loss of use, so 100% schedule loss of use of an arm gets you 312 weeks of workers' compensation benefits. So if you have a 10% disability to an arm, you get 31.2 weeks. It's 10% of 312. A leg is worth 288 weeks. So if total loss of use of a leg is 288, if you have a 10% of a leg, you get 28.8. We multiply the number of weeks of compensation in your schedule by your maximum rate of compensation, which is 2/3 of your salary, subject to the statutory maximum. There is a max weekly benefit. And then your prior payments are subtracted, and there's your schedule loss of use award. Oftentimes, if we're able to negotiate an agreement with the insurance company, we will settle a case with a schedule loss of use via a stipulation, which is simply an agreement of the parties. If we're not able to reach a stipulation and we can't agree, then we let the judge make a decision as to your schedule loss of use. Now, we've also discussed non-schedule loss of use awards. These are core body injuries, head, necks, and backs, heart attacks, strokes, brain injuries, basically anything that's not a schedulable injury, not an extremity injury. You might be entitled to benefits for your non-schedule loss of use award. This is determined by your percentage loss in wage earning capacity. We call it LWEC, loss of wage earning capacity. And you usually receive those as bi-weekly checks, the same way you got your lost time benefits before you were determined to have a permanent injury. The amount is determined by the non-schedule loss of use chart. For instance, if you're found to have a loss of wage earning capacity between 40 and 50%, you get 300 weeks of benefits at the rate that you were found to have a disability. So if you have a 45% disability, you get a 45% rate for 300 weeks. If you have a 70 to 75% disability, you get more. You get 400 weeks. So you get more money, a higher rate for a longer period of time. So as your disability goes up, your rate goes up, and the length of time that you receive that money increases. Much like schedule loss of use cases, we can also reach an agreement with the carrier and enter into a stipulation reflecting the agreement of the parties regarding your LWAC, your loss of wage earning capacity. So, we could sit down with the carrier and say, look, we're pushing for a 90%. They might say, no, we think it's a 50%, and maybe we're going to agree to a 70. If we do that and everybody's on board, we could put it into a stipulation and settle your case and be done with it that way. Once you have a determination as to your LWEC, your loss of wage earning capacity, and we know the rate that you're entitled to and the period of time that you're entitled to receive those benefits, we can enter into a Section 32 then. Section 32 is the most common type of settlement. It's a full and final closure of the case in exchange for one lump sum payment. So, when we know that you're going to be getting $500 a week for the next 400 weeks, those are finite numbers that we could sit down and figure out. You don't get the full value. A lot of people get upset and they say, look, I'm supposed to get $500 a week for the next 400 weeks. That's $200,000. They're not going to give you the full cap. They give you present dollar value. And, usually you get 50, 60, 70, 40% of whatever that cap is in one lump sum. So that's one way of closing a non-scheduled type of case. And it happens all the time. Very, very common. Section 32 settlements are not just for non-scheduled types of cases, though. Section 32 settlements can be used in any type of case as a full and final resolution of any or all of the outstanding issues in a case. So we could Section 32 a broken arm. We could Section Section 32 a bad back. We could Section 32 a case with a broken arm and a bad back. Section 32s are very versatile. They allow us to be creative when we need to be creative and put closure to cases for value for you, the client. Also, since we're talking about Section 32 settlements, not every Section 32 is a full and final closure. Sometimes we enter into what is known as an indemnity-only Section 32, and this is where the medical portion of your case stays open. We settle the money side of things, but we leave your right to medical treatment open, and sometimes we have to do this. Sometimes clients request it, and if we can get the insurance company to agree, that's great, but insurance companies like to close cases completely and totally and forever. So it's not always possible to keep your medical open, but sometimes we have to. Will I be able to go back to work after my workers' compensation case is over? And what if my employer doesn't have a position for me? So there's a lot of different potential scenarios that somebody might face here. First, you return to work, you make a recovery, you get better, and your employer held your job for you, and you simply go back to work at the same pay rate that you were at before, and you put that bad part of your life behind you, move on. And that's really the best. Sometimes, if you do have a permanent injury, you have to return to work with restrictions. If you have suffered a permanent disability and you now have restrictions on the work that you can do, your employer might provide you with a different job that can accommodate you. And this is light duty work. Light duty is a buzzword. We got to be careful with how we use it. In the workers' compensation world, we deal with reduced earnings. If the pay that you are receiving at your new position since you've gone back after your accident is less than what you were earning at the time that you were injured, you might be entitled to receive reduced earnings benefits. Reduced earnings benefits are generally calculated as 2/3 of the difference between your pre-accident salary and your current salary. So if you were earning $1,000 at your job before you got hurt and now you're only able to earn $400 a week, you're entitled to 2/3 of the difference. The difference is $600. 2/3 of that is $400. So you're going to work and earn your $400 a week, and we're going to try to get workers' compensation to pay you another $400 per week for the difference in your salary. That is reduced earnings. Another scenario you might run into, there's no job available. It's possible that your employer had to fill your position while you were away. They are allowed to do that, and it's unfortunate and it's bad news to tell people. But if you can't do your job and your employer needs that job to get done, he can bring somebody else in to do your job. If that's the case, then your workers' compensation claim is there for you to get you the benefits to compensate you for any permanent disability that you have since you can't go back to that job. This is why it's especially important to have a good lawyer who knows workers' compensation in and out, especially if you've suffered multiple injuries or injuries to multiple body parts. A good workers' compensation attorney will know how to navigate your claim down a path to maximize your benefits. So make sure you speak to an attorney who knows what they're doing and get the money that's yours. It's your money. As always, folks, this is Rex Sikowski, your workers' compensation attorney here in New York. If you want to give me a call anytime you want, 212-406-8989. Always here to help. What if my employer can't accommodate my restrictions after my workers' compensation case, and what do I do for work? Sometimes the hard truth is you just have to go out there and find another job. Like we said before, your employer is allowed to replace you and get somebody in to do your job. Again, it's an unfortunate truth. It's just the way it is. Sometimes you just got to go find another job. If you're able to find another job paying you the same amount or more than you were earning when you got hurt, then you wouldn't get any wage replacement benefits. You'd be back at full duty. Regardless of the physical nature of the work, there's no reduced earnings. You might still be able to receive an award for any permanent loss of use if you go back to work at full wages. If you had an arm or a leg or a hand or a foot injury, then even if you do go back to work for a different employer at full or more wages than you were earning when you got hurt, if you have those types of injuries, you might still be entitled to an award. You could also collect reduced earnings. If you find another job and due to your injuries, you can't earn as much as you were earning at the job you were working at when you got hurt, you could be entitled to reduced earnings benefits. The same way we discussed before. If you go back to your old employer and you're earning less because of your injuries, you would be entitled to reduced earnings benefits. Other options, you might be eligible for vocational rehabilitation to help you transition to new employment that could accommodate your injuries and your disabilities. Here in New York, the Workers' Compensation Board does offer vocational rehab in certain circumstances. Usually the judge makes the referral, but there are also a whole variety of state and local agencies that provide all different types of assistance, whether it's job retraining, helping you look for work, helping you perfect your resume. There's all sorts of things out there. You could also potentially collect unemployment. Now, you got to be very careful here. And if you have a lawyer, you have to discuss this with your lawyer. If you are ready, willing, and able to return to work, but your job is no longer available available with your employer, you might be able to collect unemployment insurance. If you're unable to find other work, okay? Generally, in this circumstance, your workers' compensation benefits for your lost time will stop or at least be reduced since your doctor has most likely cleared you to return to work, whether it's light duty or full duty. So be very careful. Make sure you let everyone know if you've applied for or if you're receiving unemployment insurance benefits. If you don't tell anybody, the insurance company is going to make a very big deal of it. Other things that you need to be mindful of: maintaining labor market attachment, okay? If a judge finds that you're partially disabled or your doctor has found that you're partially disabled, then you have to maintain labor market attachment. You have to demonstrate labor market attachment by looking for work within your physical restrictions in order to continue to receive benefits. So what does that mean? You have to look for jobs that you potentially could do, and you have to put forth a good faith, diligent, continuous, ongoing search for work within your restrictions in order to continue to receive benefits from the workers' comp carrier. Lastly, if you were fired or you were otherwise discriminated against, you could potentially take action against your employer under those sets of circumstances. In New York State, an employer may not discriminate against a person for filing for or participating in a workers' compensation claim. So they can't discriminate against you if you file your own claim, and they can't discriminate against you if you were asked to testify in a coworker's claim. If they do, you may file a discrimination claim with the Workers' Compensation Board. So that is a possibility as well. What if my injury gets worse after my workers' compensation case closes? Can my case be reopened? So if you experience complications or a worsening of your original injury years after the case was closed, you may be able to reopen your case to get more medical treatment. You will need to provide medical evidence of a worsening of your condition. That's why it's important that you keep in close contact with your doctors if any problems arise. In New York State, there are time limitations for reopening a case. If there was no award, you can reopen your case within 7 years of the injury date. If there was an award, you can reopen within 18 years of the injury date and 8 years since the last payment was received. In some circumstances, you can't reopen your case. If you settled your case with a full and final Section 32 agreement, the only way to reopen a case is with the consent of all parties. And this is incredibly unlikely to happen because the insurance company just paid you a lump sum of money to close your case. So it's highly unlikely for them to agree to reopen your case. That means that you are likely on the hook for any future medical treatment that's related to your underlying workers' compensation case and those injuries moving forward. And there is provisions in full and final Section 32s that allocate money for future medical care. Sometimes it's an agreement of the parties. Sometimes it's more formal in the form of a Medicare set-aside that is mandated by Medicare and the federal government. But if it's a full and final Section 32, there is a provision in there for allocation of money for future medical care. There is also the possibility of filing a new claim. And this is not a way to beat the system. This is just me explaining that people sometimes get tunnel vision. I hurt my back 5 years ago and I've had this bad back and blah, 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 blah. And they don't realize that when they slipped and fell in the grocery store, that's a whole new accident. And it's not just an exacerbation of the bad back that you had. That's actually a new accident. And whether or not it's a lawsuit, a workers' compensation claim, or nothing at all, it's a new accident. And it should be treated that way regardless. So what does that mean? If you have a new accident or a new injury, you might be able to file a new claim if it's work-related, a new workers' compensation claim, even if the injury is to a body part that was previously hurt in a different accident. Sometimes people lose sight of this when dealing with an existing injury, but you can have multiple claims with overlapping sites of injury. It's just something to keep in mind. If you guys have any questions whatsoever, feel free to call 212-406-8989. Thank you for joining me today, and I hope to speak to you guys soon. Have a wonderful day.